Thank you for listening to our podcast, Módulo Músicos Unidos. It's a design podcast for a community of musicians, artists, producers, songwriters, and even publishers. So anything that has to do with music in the music industry, all the news and latest updates. Again, the name is Módulo Músicos Unidos. Stands for it's like a module, Musicians United. Okay, that's the what it means. This is our 12th episode. There's mixes of variations of episodes, most in Spanish, and we'll do some in English as well. My name is Max. I am founder of MMP Global Music. You can visit our website, mmpglobalmusic.com. We're also independent, and we do music publishing, and we do other label services as well. Okay, so in this episode, we are going to touch base on what's happening with the copyrights in a case it's currently in the courts, and we'd like to inform those listeners, musicians, and artists of what to do or what to be aware of. All right, so we'd like to start on the U.S. Court of Appeals for the Ninth Circuit in reversing a grant of summary judgment in favor of defendants found that digitally remastered 1972 sound recordings. So these are all the recordings prior to 1972 were not or are not entitled to protection under federal law as new copyrighted songs. Okay, so this is a current case that's happening. It's ABS Entertainment Inc. versus CBS Corporation. So this is a case in the state of California, which we'll go over briefly. There was an article that was written regarding this case, and that's what we're reviewing and letting everyone know in the industry exactly what's happening and what's protected and what's not protected. All right, so in this case, just to give you an overview, ABS owned several pre-1972 analog recordings of classic songs. So what they did was they hired remastering engineers to remaster those songs into the digital formats. Okay, so that they can be played, and technically they wanted the new copyrights. Okay, so they remastered the songs to digital formats using the standard technical process to create accurate reproductions, okay, of the analog recordings. So it ended up happening that CBS, okay, played those remastered songs through the normal AM and FM radio, or terrestrial radio as they call it, in the digital internet streams without permission. Okay, so for all of its broadcast content, CBS paid a royalty to the owner of their own underlying musical composition. Okay. However, for the digitally streamed content, CBS paid the compulsory license fee under the Sound Recording Act to Sound Exchange. Okay, so Sound Exchange, was established, to collect these fees. So we can get into that in another episode, as far as the meaning of that and they collect. So for the content delivered by terrestrial radio, CBS paid no license fee at all. All right, so there's a lot of legal issues regarding, who's collecting what based on the remastering of those songs. So that's the challenge there, and that's why I headed to court for dispute. All right, so then we have ABS filed a class action lawsuit alleging that CBS was publicly performing their pre-1972 songs in violation of the California state law. All right, so going back and forth, CBS argued that the digitally remastered recordings were authorized original derivative works, okay, subject to federal copyright law and not protected under the state law. So basically the issue was whether a sound engineer remastering, which is involved subjectively and artistically altering the works, the sound, the balance, the loudness, all that, but otherwise leaving the work unedited was entitled to that federal copyright protection. So the Ninth Circuit stated that the derivative work is copyrightable when it meets two criteria, okay, under the test set forth, and that's another case, Durham Indus, versus Tommy. The Ninth Circuit noted that a digital file that does not add or remove sounds from the underlying recording, does not change the sequence of the sounds, and does not remix or otherwise alter the sounds in sequence or character, is very much likely to be nothing more than a copy. Okay, so that devoids of authorship required for copyright protection. Okay, so technically, the circuit concluded that the district court applied an incorrect test for copyrightability, and in doing so, placed a critical reliance on the testimony of CBS's expert. Okay, so that's basically the bottom line. If independent artist or artist that has pre 1972 recordings, if it's going to be remastered, it has to be remastered completely, not just that sounds like a copy, but it has to be, the sounds have to be altered. It has to be some sort of variation to the sound, okay, or even the recording, so it can fall under that copyrighted status, and not be exposed to be sued. Okay, so we just wanted to bring that information out to those who have pre 1972 recordings, and just to let you know what's happening, and if there's any remastering, make sure that it's altered enough that it's not, doesn't fall under a copy. All right, because you certainly don't want a sound recording to be a copy. Of course, you run into all these kind of issues. Okay, so thank you for listening to our podcast, Módulo Músicos Unidos. You can feel free to leave your comments below, and any questions that you may have. We're here to help.